Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Case number 20-3012, United States of America versus Waldemar Lorenzana-Lima, also known as Waldemar Lorenzana-Lima, appellant. Mr. Zucker for the appellant, Ms. Hostetler for the appellee.
Morning, counsel. Mr. Zucker, when you're ready, please proceed.
Thank you very much. John Zucker on behalf of appellant, request 5 minutes for rebuttal. The issue before us is, well, there's essentially two issues. The first issue being whether or not there was a waiver of a sentencing enhancement during the plea proceeding. As the court's well aware, 11B1N requires that the court to advise when there is a sentencing waiver. And I will concede at the outset that the plea agreement, the written plea agreement, complies with all the requirements. The issue before us, and it's the issue that arises, and I guess the lead cases in this jurisdiction are the Brown and the Godoy case, is when the inquiry or the colloquy between the court and the defendant at the time of the plea creates an ambiguity that could cause confusion. And we are not, again, challenging that there's an ambiguity about the entry of the plea. We are challenging only whether there was an ambiguity and confusion created by the court's colloquy in relation to the defendant waiving the sentence enhancement. And the court's comments at the time, respectfully, raised that issue. The court says if the sentence exceeded the maximum, which would be an illegal sentence, frankly, or if there was an upward departure. And at the time, in this case, there was, although there was an agreement on plea, there was a dispute between the parties about the sentencing guidelines calculations, and particularly the leadership enhancement. And the danger here is that the court's colloquy did not apprise the defendant. He was waiving his right to challenge that decision from the court.
Can I interrupt with just one question back about the plea agreement itself? And the plea agreement itself, was he ever given a Spanish translation? It sounds like from the transcript that it was just explained to him orally by his attorneys, but was he ever given a Spanish translation of the plea agreement?
I don't think so. I don't know. In all candor, I was not at the trial level. My recollection from the transcript is the same as yours, that he was given an interpreter that did the translation, but not a printed translated copy. I know his lawyer was also a native Spanish speaker, and I don't know if that matters. But no, I think the answer to your question is no, but I'm not sure.
Okay, sorry to interrupt. Go ahead. Yes.
No problem. So anyway, the issue becomes is when the court says, the court never said to the defendant, an illegal sentence would only be that which exceeds the statutory maximum of 40 years. And as the Brown court pointed out, we have to analyze these in the context of who is the defendant, what is his background, what is it reasonable to expect of him? And as the Brown court pointed out, it's not reasonable to expect a defendant to understand the legal argot and understand the nuances of maximum upward departure versus enhancement. And that's why this case is here. And that's why I suggest that there was not a valid waiver during the colloquy. There was confusion during the colloquy, and the defendant proceeded and his substantial rights were prejudiced. So if the court agrees with that, we turn to the second issue, is whether or not—
Before you do that, can I have another question? I have another question on this.
You're allowed to ask as many as you want.
I know that Mr. Lorenzana-Lima doesn't speak English, and so had a Spanish translator throughout the plea hearing. Is there any transcript or recording of what the Spanish translator, the words that the translator was using?
Not that I'm aware of, and I sincerely doubt there would be. And I think it would also probably be his lawyer. That would probably be a privileged conversation. But as far as I know, there's no record of exactly what the Spanish translator—
I'm not sure why, right. I don't know why the translator's translation of a public proceeding would be privileged.
It's a good question. If it was a public proceeding, then by all means.
The plea hearing, I'm talking about the plea hearing. I'm only talking about the plea hearing itself.
My experience is that the court reporter doesn't speak Spanish and isn't recording those conversations. So I don't think there could have been, normally what happens is the there's a staccato presentation where the
Yeah, I know. I just didn't know if there's any recording of the translation, since that could be relevant sometimes. So okay.
I would say with confidence, no, because those
Okay.
are traditionally not done. So no. And I would assume that the translator and or the lawyer went through the plea agreement prior to the courtroom. I mean, that's certainly standard practice is for a lawyer to review it. And I don't know, if it was done with an interpreter or not. Knowing the lawyer, knowing he's a native Spanish speaker, I would assume he would have reviewed it in person beforehand. I mean, that's what we do with all our clients.
Okay.
Have
So
you made any claim, Mr. Zucker, on behalf of your client that but for this so-called ambiguity in the meaning of it, that he would not have pled guilty?
No, I don't think the issue is whether or not he would have pled guilty. I think the issue is whether he would have waived the sentencing enhancement appeal. That's, I think, what the issue is. We're not seeking to withdraw the plea here. And we're not complaining that there was a constitutional defect or any other defect in the plea itself. Our error that we're alleging is that the waiver of the sentencing challenges was not appropriately done.
So just so I understand, under the plea agreement, there were only two circumstances in which an appeal would be allowed of the sentence, right? One is if there was an upward departure from the guideline range, and two, if the sentence exceeded the statutory maximum.
Yes, your interpretation of the written plea agreement is correct.
Okay, and neither one of those circumstances is materialized. Is that correct too?
Yes, and I agree.
And yet he says I mean, your position then is, nevertheless, he still can appeal.
Yes, he can appeal because there was an ambiguity in the colloquy with the court during the plea hearing. It's the exact situation as in Brown, as in Godoy, where during the colloquy, with all due respect to the trial court, confusion was created about the waiver of the sentencing enhancement.
So can I ask about that, about the colloquy?
Mr. Zucker, is it this statement that, so if it was unlawful or involuntary or some other fundamental defect of a constitutional nature, you can appeal that? Is that the ambiguity? Is that the sentence?
Well, I think it's several of them. It's that. It's also the lines about, but you could appeal if the sentence exceeded the maximum, without defining that the maximum is the statutory maximum rather than the guidelines.
But a few pages earlier, he did say the statutory maximum, didn't he?
I believe that's correct, but then the ambiguity is created in terms of the last part of it, where he says, okay, but you could appeal.
Well, let me just ask you about the sentence that I read to you. So if it was on,
I'm sorry, Judge, if I don't have that part of the transcript, which part are you relying on?
It's in the supplemental appendix of page 102 to 103.
To 103. It's you rely on it.
Yeah.
It's at the top of 103.
Forgive me, I don't have it printed out. If you could read it.
All right. Well, I'll read it to you again. So if it was unlawful or involuntary or some other fundamental defect, you can appeal that. How can a sentence be involuntary? I mean, how could anybody possibly understand that line? Can you think of a voluntary sentence?
That's really not the part I'm focusing on that created the confusion, Judge. I would direct the court. It's on page 79 of the appendix, where it says, but you could appeal if the sentence exceeded the maximum, which would be an illegal sentence, frankly, or if there was an upward departure that the court imposed.
But I thought you were making two different arguments in your briefing, at least. One was that you get some ambiguity out of the maximum part, which is what you've been focusing on this morning.
Right.
But then another one was that you get some ambiguity out of the sentence that Judge Randolph just read to you. I thought you were making two different ambiguity arguments. And if we just put to one side for the moment, the maximum argument, I know you don't agree with me, but let's just assume for this purpose that maximum means statutory maximum. And we just focus on the other source of ambiguity that you identified in your briefing, which is the sentence that Judge Randolph identified. And on that, do you have a response to the question about the use of the word involuntary?
I guess I have a response to saying he certainly wasn't voluntarily conceding to the enhancement because that was being contested throughout. Now,
but I guess the question is this, so the sentence, just to refresh your memory, is so if it was unlawful or involuntary, some other fundamental defect of a constitutional nature, you can appeal that. And it seemed like both you and the government are rightly focused on that sentence. And it seems like there's common ground on the following, that if the word "it" was replaced by plea, that would be one thing. If the word "it" was replaced by sentence, that would be another thing. If it was sentence, then it would favor you. If it was plea, it would favor the government. And the question would be, if it's sentence, it also uses involuntary in the same sentence. So why is not the inference from that one would understand her to have been referring to the plea rather than to the sentence? You may well have an answer to that.
I mean,
I'm just curious about
she was referring to the plea, but I think what I would focus on there.
I'm sorry, what did you just say? I didn't hear
it. Could be I'm not sure which the court was referring to on the it. So that's really part of the confusion and ambiguity. But the other portion of this was the confusion between upward departure and enhancement and the unlawfulness. It would be unlawful to enhance a sentence. To apply the leadership enhancement absent a factual predicate for it. And I think that's where part of the ambiguity lies here, or the central part.
Well, you also have a due process argument, right? I thought
Yes.
Part of your argument was that there's a due process problem with relying on the proffer statements when the defendant was not allowed access to the proffer statements.
Yes. I mean, certainly that is the due process. And those proffer statements were incorporated into, the government claims that it was a trial transcript, but much of what they're relying on doesn't occur in the trial transcript. And we've gone through the facts on that. But the proffer statements were incorporated into the pretrial services report. I mean, that's where they get their facts from, is what the government disclosed in their interpretations or their summaries of the proffer statements. So that's a due process argument. Judge Randolph, did I answer your question? I'm not sure I responded.
Yes and no. I think that you answered the question, but I don't know if you did it satisfactorily. But one of the other things that strikes me is that the plea agreement itself said the manner in which the judge imposes the sentence cannot be challenged on appeal.
Well, but the question is, when the plea colloquy injects confusion into it, what is controlling? And I look at I think it's a Godoy case that says, look, if we could look at a plea colloquy to interpret and rectify an omission in the plea agreement, then we have to look at the plea colloquy to see if that infects confusion or misunderstanding. And I suggest that's what occurred here. Especially, if I just complete, especially when we're talking about somebody with this background, second grade education, another country, not familiar with the nuances of our law, let alone sentencing guidelines, and the distinction between an upward departure versus an enhancement.
Yeah, your argument reminds me of something the philosopher Karl Popper used to talk about, and he one of his principles was that if you have to define your terms before you can speak, nobody could speak, because more definition doesn't lead to greater clarity. It leads to infinite regression. And if every time the word "it" is used in a plea colloquy, the judge has to define it, it's going to lead to infinite regression, because when you define something, you use words, and when you use words, you have to define those words.
All right, I'm not going to quarrel with you, but I think, with all due respect to the trial court, it created confusion rather than clarity. Yeah. And I think, had they summarized it to say, had she said, okay, the maximum I'm talking about here is the statutory maximum, not the guidelines, for instance, or had she clarified upward departure versus enhancement, for somebody in my client's position, those are confusing terms, and it's unfair to expect him to understand the nuances and the differences between them based on the colloquy that was given.
His lawyer said that he did understand them. Was the lawyer under oath?
Well, I mean, the lawyer could give his understanding. I don't. And the lawyer, I think, could only comment on what occurred in terms of interpreting the plea agreement. But it was when the court tried to clarify or tried to summarize, I guess, during the plea colloquy that I think the confusion was created, because it said you can appeal these issues, and these issues, if there's a constitutional defect or there's an upward departure, and to this person, to expect him to understand the nuanced difference between an upward departure and an enhancement is unrealistic.
Can I ask you on your second issue? I just want to make clear something. Are you raising a Jenks Act argument? Because you talk about that they didn't give you information about the folks whose testimony was being used, but I wasn't clear from your brief if you were still pursuing the Jenks Act argument. You definitely focused on the
I don't think we presented it as that, because I don't think Jenks would have applied.
Okay, I just want to be clear.
I don't know, but I assume trial counsel was given the Jenks of the witnesses that did testify.
Yeah, it was a little ambiguous to me. Okay.
I think there were other witnesses that related to the proffer that weren't called, and I think that was the basis.
Okay.
Actually, I'm wrong on that. Can I have a quick moment to consult? But was there additional Jenks that wasn't disclosed? Apparently, I misspoke. There was a Jenks request that was not complied with, but I think it related to aspects of the witnesses' cooperation that weren't relevant, particularly to sentencing. Is that correct? No.
You can also clarify it on rebuttal if you'd like.
Okay.
But I thought that
that's a better idea.
I thought that the principal argument you were making, I didn't see you make a Jenks Act argument actually in your briefing. I know you noted it.
I didn't. Okay. Yeah, I didn't. I'm just responding to Judge Millett's question.
Sure. No, absolutely. Yeah.
I was just trying to clarify. Okay.
Yeah, and appropriately.
Yeah, our contention was that there was a due process violation because the proffer statements weren't disclosed in advance, and there was a there was just an interpretation. Let me try and phrase that better. The leadership enhancement should not apply based on the facts that were presented, because Lorenzana-Lima didn't have control over anybody. He had control only over the property. He didn't negotiate anything. He couldn't fire anybody. He didn't set any prices. He didn't do anything except to say, yes, you can use my property. And he consented to that. And he wasn't even involved in the negotiations. His kids took care of all that.
Got it.
Okay.
Let me just make sure my colleagues don't have further questions for you at this point. We'll give you a little time for rebuttal.
Thank you.
Okay, thank you. Ms. Hostetler, we'll hear from you now.
Your Honor, may it please the court. I'm Kelly Brooke Hostetler and I represent the United States. Lorenzana-Lima waived his right to bring these claims when he pleaded guilty. He acknowledges that this is covered by the written plea agreement and nothing in the plea colloquy conflicts with that written plea agreement. As he went into the plea, at the start of the plea colloquy, the district court asked him to let him know if anything that he said contradicted what he understood from his attorneys prior to the start of the plea colloquy. When he signed the plea agreement, he said that he understood it. His attorneys attested that they had fully explained all of the consequences of it. And the statements that the district court made were not ambiguous. And to the extent
can I ask you about that? Just because I think it's at least common ground, I think, between you and the defendant's counsel that even if the plea agreement was totally clear, that things can happen in the course of the colloquy that inject sufficient ambiguity into the dynamics such that the individual is not bound by the plea waiver anymore, right? I mean, that's common ground under our decisions. So then the question becomes what exactly happened during the colloquy. And on pages supplemental appendix 102 to 103, the ones we were speaking to Mr. Zucker about earlier, the district court starts out by saying there's two kinds of appeals. There's an appeal based on the statute, and you're giving up those rights, and I'll go over those in a moment. And then it seems like she switches to the second kind of appeal because she laid out that there's going to be two kinds of appeals. The second kind of appeal is your right to appeal any constitutional defects you're not giving up. And so why isn't the right way to understand that, or at least a reasonable way to understand that there's statutory defects you could be appealing about, and then there's constitutional defects you could be appealing about. And then the constitutional defects, you're not giving those up. The statutory ones, you did give those up. And he is making a constitutionally grounded sentencing appeal here, in that he's saying that there's a due process problem with relying on proffer statements that were never given to me.
Almost immediately after that sentence from the district court, she goes on to explain the statutory sentencing right that he's giving up. But as part of that, where she says he's giving up his right to appeal his sentence, she also says you're giving up the right to include any challenges to the constitutionality of the sentencing guidelines. So it can't have been that the first was just all about constitutional challenges and the second was just about
Well, but there's a difference between the constitutionality of sentencing guidelines and a constitutional claim relating to the sentence, to the administration of the sentence, right? And so even if that's true, even if subsequent statements, it would be one thing if a judge said, and I'm not saying that any judge could be expected to do this on the fly. I think this is a really difficult thing to do. I don't mean to slight what a district judge faces here, but it'd be one thing if a judge said, let me just scratch what I just said. Let me start over. Here's a clarified understanding. And it would be another thing to go on and elaborate in a way that doesn't necessarily, in the defendant's eyes, clarify what had been said before. And so even if later on there's a reference to constitutional challenges to the sentencing guideline, that wouldn't necessarily ameliorate an indication from prior comments that you can raise constitutional defects.
Well,
or would it?
I think looking at everything in context, I mean, starting with where the defendant would have been when he came into the plea colloquy, which is understanding that he can't appeal his sentence as long as it's not above the statutory maximum or is an upward departure, has been told that if he hears anything that conflicts with this, he should let the district court know. And then he hears, if there's any concern or question at that point in time about, oh, maybe I could bring a constitutional challenge to my sentence. She goes on to clarify that, saying, no, this is not just, A, constitutional challenges and B, statutory challenges. We're really talking about appealing the conviction versus appealing the sentence, with her later clarification, which comes almost immediately after. And if you have any, sorry.
Can I just ask this question then, and then I'll stop this line of questioning, which is, if the colloquy stopped after your right to appeal any constitutional defects, you're not giving up, you're not waiving that. So if it was unlawful or involuntary or some other fundamental defect of a constitutional nature, you can appeal that. And if it just stopped there, then at that point you would agree that there was ambiguity. But then what you're is that right, or am I wrong? And what you're relying on is subsequent statements that clarified what she was saying.
I think the subsequent statements are really helpful and really important, but if we were presented just with that, I'm not entirely sure that would be ambiguous either, for the reasons Judge Randolph said, because of this phrase of involuntary, which makes it seem like we really are talking about the plea there and not the sentence. But here we don't have to parse that, because we do have the immediately thereafter clarifying statements. And the same thing with the second statement.
Can I follow up on that? Just to follow up, because that sentence that you were just now referencing, the unlawful and involuntary, is preceded by you're giving up all your rights to appeal. Now, I assume that language includes both challenging the plea and the sentence.
Yes.
All your rights. And then she says there's two kinds for all your rights. There's statutory and constitutional. She hasn't narrowed it yet from all your rights. So the constitutional defects must refer back to including constitutional defects, right, in the sentencing. And that's when she says you're not giving up or waiving those. And then we have this, so if it was unlawful. And I had asked, is it your understanding too that there's no recording of the translation that's done by the Spanish translator?
That's my understanding as well, but I am not positive.
Okay. Well, it's just because we all talk about it, but in Spanish, there's different words for it, depending on the noun that pronoun is referring to. And it could very well, at least on some translations, it's different whether it's talking about an agreement or a sentence.
Right.
So I think it's a little hard to rely on the singular English meaning of this, that we are thinking about. We have to understand that in Spanish, we have to look at this from the perspective of the defendant with a second grade education, that there's not a single it in Spanish. And if all the language up to that sentence was about waiving all appeal rights except constitutional defects, which were both plea and sentence. And then you have one word that seems to describe a sentence and one that could describe the plea. I don't understand the argument that we suddenly know because of it, that everything in that sentence was only talking about the plea when nothing before it was narrowed down to just the plea.
Well, again, I do think you can look at what comes after it, where the court makes clear that you just can't bring any constitution.
Well, what comes after that is, you're willing to give up these rights? And he says, I didn't understand that on 104. And then she gives a super high level, just understand you're giving up these statutory rights. And she says, I agree with that. So you gotta, if we're gonna look at the whole transcript, which I agree we should, we gotta look at the before and the after. And then this is, I think we have to look all the way to when his lawyers say, look, this has been very difficult. He said he just wants to plea and he'll sign anything we put in front of him. I mean, there's a lot, this is one of the most extraordinary plea transcripts I have ever read. It's deeply troubling, honestly. On, you know, so the efforts to just find some magic formulation of words that he would agree to. So, and I don't think these other clarifications you're talking about they're not right next to it. They come pages later. So what are we to do with that?
Well, first of all, the difficulty in getting him to agree was on the articulation of the facts. That was what the real sticking point was. It was not on the waiver of the rights.
Well, but it was in that context that the attorney said, look, this just guy wants to plead and he'll sign anything we put in front of him, and was never even given his own Spanish translation of the plea agreement. And so that I think that was not limited to the facts. They were talking about his state of mind and how he was approaching this whole process.
Yes, although I don't read from the transcript any reservation on his part in terms of the rights he was waiving, but only in terms of what responsibility he would have and whether he would be exposed to the leadership enhancement and whether he would have responsibility or whether the responsibility would be attributed to his sons. And I would also point out, I mean, there is that immediate clarification on page 103 of the government's appendix, but also later on, there is that discussion of the statutory maximums at page 147 to 149, where the district court clearly defines what an illegal sentence would be and makes clear that it's referring to a statutory maximum. Mm-hmm. I would also point out that—
normal not to provide, oh, I'm sorry. You want to finish your point? Go ahead.
I just wanted to say, I would also point out that in the middle of the plea colloquy, he did have almost 30 minutes with his attorneys in private. So if there were issues about the rights he was waiving at that point in time, it would have been an opportunity for him to discuss any confusion that he had and to clarify it with his attorneys at that point in time, if there had been things that were surprising.
Well, there was a lot of water under the bridge by that point, and it seemed like the attorneys were just trying to figure out some formulation of words that he would be able to say yes to. Is it normal not to give a Spanish translation to a Spanish speaker of the plea agreement itself?
I don't know why that wasn't provided in this case.
It is normal, right? Isn't that the normal? I thought you see many more of these than I do, so I won't. I'm just, in my experience, it's generally we've been informed that they've been given a Spanish translation, so I was confused here.
I don't know why there wasn't one given.
But that is more the more ordinary practice is to do so.
I don't know, Your Honor, what the normal practice is.
Oh, you don't know?
I don't know.
Oh, okay. All right. Okay.
Can I take you past the waiver then, just for arguments purposes? I know your argument is that we shouldn't get to the merits at all, but if we get to the merits, unless my colleagues have further questions on the waiver, I just want to go to the merits for a second. So on the merits, on the part of the argument that's made by the defendant to the effect that both the government and the district court relied on Linares Cordon's indication that Lorenzana-Lima was the leader and was largely deferred to. And as I read your brief, your argument on that is harmless error, because it doesn't sound like you really take issue with the notion that there wasn't trial testimony that supported that proposition. It would have had to have come from the proffer statements, and right, if it came at all. And so you're not disputing for our purposes the notion that that part of it came from the proffer statement. The only question is whether, even if that was erroneously injected into the equation, that it was harmless, right?
Your Honor, I'm not even sure that comes from the proffer statements. It's not clear from the summary of the proffers. It just seems like it was a conclusory statement that got in there and then got repeated.
Right, exactly. And it was injected by the government, to be fair, and initially, and the district court picked up on it. And so then the question becomes, is that harmless? As you rightly, I think, surmised in your brief, that's where we should point point to on that. And on that, the district court did say in its opinion it did rely on it in its opinion in imposing the leadership enhancement. It did say at 324 of the appendix, the government asserts that both Herrera Garcia and Linares Cordon acknowledged Mr. Lorenzana-Lima as leader of the DTO. So that seems to be a reference to it. Then on 327, there's a statement, he, being the defendant, was seen by his co-conspirators as the leader and point person in control. And I don't think we're talking about the sons there. I think we're talking about Herrera and Linares because the sons are referred to separately. And then in concluding, there's the statement on 329, both Herrera Garcia and Linares Cordon deferred to him, as did his sons. And so there was at least some reliance on the notion that Linares Cordon had identified Lorenzana-Lima as the leader, i.e. somebody to be deferred to. That seems to be have made its way into the decision in a few places. And the question becomes, if that's true, then how is it harmless beyond a reasonable doubt, assuming that that's the right standard?
Yes, I think the evidence is overwhelming that the district court points to based on just Herrera Garcia's testimony alone, which she carefully documents in the written order. Also, again, in her sentencing colloquy, or at sentencing, she goes through her reasoning again. And there she specifically says she went back and checked the transcripts and they are correct. And there's no reference to Linares Cordon and his deference at sentencing. Just looking at the evidence based on Herrera Garcia fully demonstrates that Lorenzana-Lima was a leader or organizer.
Even if that may be true as a matter, that could, in other words, I mean, if it was a sufficiency challenge, then you could say that, yeah, the evidence was definitely sufficient. But in terms of the way she characterized her finding that the leadership enhancement was met, there's multiple places in her written rendition of it that reference the exact thing that we have to assume for our purposes came from the proffer.
Yes, but she cites to she doesn't cite to the transcripts there. Again, those are also very perfunctory and conclusory statements, whereas where she's relying on the evidence, it's all cited to Herrera Garcia, except for one small reference to Linares Cordon in terms of the scope of the conspiracy, for which she was an appropriate witness. And when you look at what she says at sentencing, there is no mention of Linares Cordon, and she sets out the evidence there as well, clarifying if there was any question, clarifying what her decision-making was.
Yeah.
It sort of struck me, I'm sorry, you.
No, go ahead. Thanks.
It struck me that the language, you say the evidence was abundant from Herrera Garcia, who was a cooperating co-conspirator. But all the language seemed to be in terms of he had concerns, he suggested, he advised. That's not language that at least I'm used to seeing in these types of enhancements. If I'm meeting with my law clerks on how to deal with a case and they make suggestions to me and have concerns that are expressed about a certain course of actions and provide me with some advice, and I follow that, are they leaders in this chambers?
No, Your Honor, but very oftentimes senior members.
If I go to case conference afterwards, after an argument, and my colleagues have concerns and advice and suggestions that I find persuasive and decide to go along with, that doesn't make them leaders of me, it makes them peers, right?
Correct.
Right, the language here seems to be one of, at best, maybe a peer or someone who, it's his property, they're gonna hear him out, and every now and then he says some things. But Herrera Garcia, who was like the point person for the Sinaloa cartel in Guatemala, he was a huge player in this conspiracy. He was a bigwig. And the notion that he was taking orders from this farmer just because he had concerns or advice about avoiding local police, it just strikes me as a very odd way to think about things. The evidence, I'm curious how you wrapped your head around that concept of leadership, rather than how can we tell that he wasn't simply just probably peer is probably too much of a word, but simply another person that he would listen to now and then.
A couple things, Your Honor. First, senior personnel in an organization often speak in softer language. They don't necessarily say, I am ordering you to do something. They sometimes speak in more polite language, even though everyone understands that it is a direction.
Wait, he's not the godfather here. I mean, you really think that Herrera Garcia, with his position in this conspiracy, was being ordered around when Mr. Lorenzana-Lima said, I'm concerned about these really large trucks coming into this small town. Maybe we should try another location. That was an order? Herrera Garcia interpreted that as an order? Did he say anywhere that he interpreted that as an order?
He didn't say that specifically, but I would give an example with respect to his efforts to expand production, the transport from El Salvador, that before he finalized any of the agreements in El Salvador, he spoke with Lorenzana-Lima to make sure that it was okay. So I think
it was okay as in like permission or simply to get his advice to make sure this is workable because he's the guy on the ground.
To get his okay, because the operations couldn't start, they couldn't expand until Lorenzana-Lima gave his okay.
Sorry, that was the evidence, at least in the record, was you're talking about sort of picking the start date or something. That the evidence was quite ambiguous whether that was simply when it would first start versus every single time. That I would have thought this is a massive conspiracy, and if this guy was the leader, I certainly would have thought there'd be more evidence in the record of him somewhere ordering someone subordinate to him. I guess you wouldn't say Herrera Garcia was subordinate to him, would you?
I would say with respect to Lorenzana-Lima's property that Herrera Garcia was subordinate in terms of how they were using it. And I would also point to the specific instance in which Lorenzana-Lima instructed, according to Herrera Garcia, instructed that the warehouse be renovated. So there were
people. Did he instruct Herrera Garcia? Or it was Herrera Garcia who wanted it renovated? Right?
Correct. And Lorenzana-Lima instructed personnel. So he was a leader organizer, even if this court doesn't believe that Lorenzana-Lima
supervised the construction.
He ordered his personnel to renovate the warehouse, which is, he only has to have control over one person under the standards and guidelines to be eligible for those.
Right. Okay. Thank you.
Okay. Thank you. If my colleagues don't have any further questions, we'll hear from Mr. Zucker for his rebuttal. Thank you, Ms. Hostetler.
Thank you very much.
Mr. Zucker, we'll give you 2 minutes for your rebuttal.
Appreciate it. To respond to your question regarding the Jenks was not provided, it was requested, but the reason the court gave was because the witnesses weren't testifying themselves, therefore Jenks didn't apply, which is, so anyway, I had misspoken earlier.
Mm-hmm.
I'd also like to note that Judge Millett, you talked about, I think it was you, that talked about there was the point where the defendant said, I don't understand that part of the waiver, or I don't understand. And then there was a re-instruction, which was really just a repetition. And then there was that pause where he takes a break. The counsel says, can he take a break? And I think all of that kind of indicates some of the confusion, some of the stress, and should cause some concern about the defendant's appreciation and understanding of exactly what the nuances were here. I think you make a good point when you talk about I'm not sure where it fits in exactly terms of the waiver, but this whole plea colloquy was troubling in the sense, number one, the lawyers were opposed to the defendant entering the plea. And it was like everybody was kind of struggling to make it go down. At one point, the trial judge says, well, it's bare bones, but I guess it'll do. I guess we've met the elements. There was the whole issue about whether or not the defendant was part of a conspiracy to distribute to the United States when he had no involvement with the United States. And they said, well, okay, but he was paid in dollars. So from that, he could have inferred that the drugs were going to the United States. The only other point I'd like to make in terms of the leadership is I think the case that's clearest here, and it should be controlling, is the Shu decision, where they said a leadership enhancement was given to a tavern owner who allowed drugs to be distributed in his tavern and had control over who came in and did it. And that was reversed, saying he didn't control anybody, he controlled the property. He didn't set the prices, he didn't do the negotiations, he didn't tell anybody what they could or could do. He just gave them permission to use his premises. That's not enough for a leadership. And that is directly analogous to what Lorenzana-Lima's control was of his property. He could control his property, but everything else.
So, Mr. Zucker, your point on the leadership is that the facts that the district court relied upon are unsupported. Is that it?
Yes, that's certainly it in terms of the factual determination. And then there's, of course, also the due process violation.
By it, I meant the district court's finding.
Yes, thank you for defining it in this context. And I would say we would allege both those its are the error. One, that there was not a factual predicate, and two, that there was constitutional violation in admitting the proffered stuff, relying on stuff without allowing the defendant access to it and the ability to challenge it.
Okay, thanks.
Is that it? Anything else? All right. Thank you.
Thank you, counsel. Thank you to both counsel. Mr. Zucker, you were appointed by the court to represent the appellant in this case, and the court thanks you for your assistance. We'll take this case under submission.
Oh, really? Let's do 25. $2 each, so $50. Yeah. You said they're $2 each? Yes. So that would be $50, right? Okay, that sounds good. Sorry? Helen King Height, so it gets Bob's last. Bob. Yeah.
Case number 20-1076 et al. St. James Medical Group petitioner versus National Labor Relations Board. Mr. Potter for the petitioner, Ms. Sheehy for the respondent.
Morning, counsel. Mr. Potter, please proceed when you're ready.
Thank you. Excuse me. Yes, my name is Terry Potter, as noted, counsel for the petitioner in this matter. And as you know from the briefing, this concerns a petition for review of an NLRB determination. In particular, this case arises out of an organizing campaign of my client's facility medical clinic in Butte, Montana, in which the Montana Nurses Association organized a group of RNs into a bargaining unit. During the preliminary proceedings in this case before the board, we took the position, the employer, that the proposed unit was inappropriate, that we had other professionals working in the clinic who should be included in that unit. And therefore, we litigated that in a hearing. The regional director disagreed with us, certified a unit of RNs only, went to an election. The union won the election. And therefore we have, through various procedures, as you know, contested it further and by testing the certification. And so here we are. And the main basis for our dispute and this decision by the board is the fact that it's not following its own guidelines. As you recall, for many years, specialty healthcare was the standard in determining bargaining units before the NLRB. That case was overturned by a case called PCC Structurals in 2017. And it changed the standard in many ways. And in particular, what it requires of the board now in making its determinations on these unit issues is that they do a much more robust analysis of the distinctions between those individuals included in the bargaining unit and those excluded. And our complaint here is that they didn't do that robust analysis, in particular. So it was.
Can I ask you how, in analyzing that argument, that they didn't, that the board didn't sort of sufficiently hew to the standard of explanation.
Right.
We don't review that. Do we review that de novo? Do we just sort of look at it and say, is this a sufficient explanation? Or do we simply ask whether the board's conclusion that this was a sufficient explanation as required by its precedent? Because it acknowledged its precedent. It didn't ignore it or apply the wrong thing. Do we ask only whether it was sort of arbitrary and capricious or unreasoned for them to think, to conclude on this record that they had explained in sort of to the same degree as their precedent requires?
I think the standard is, is it arbitrary and capricious because they're not following their own standards.
Right. So we don't go, and so it's not sort of, well, it doesn't look quite enough to us. It would have to be so clearly off the mark from prior precedent that we would call it arbitrary or capricious.
Right.
Okay.
So again, the dilemma is on this new standard, and again, this is, 2 years after PCC had issued, and there have been all sorts of guidance issued internally with the board. They just didn't do their job. They did what the Boeing case, which clarified PCC standards and came down in 2019, said you shouldn't do. All they did was have a checklist of the various characteristics of both in the bargaining unit, both outside the bargaining unit, and then come to conclusionary statements regarding who's going to be in and who's going to be out. Instead of saying, look, this issue is important in terms of a distinction between the two groups, and it's important in this context for these reasons. They didn't do that. They went to the old format, which frankly, when I worked for the board, I was as guilty as anybody, where you submitted the laundry list of distinctions that were set out in the record, and then you come to a final conclusion as to who's in and out, without expressing why one set of distinctions or similarities. Again, weighing, the cases say you have to weigh the similarities and the disparities. There's no weighing here, and there's no analysis. And that's our number one concern in this case, is that they simply did not do that. And it's a very summary analysis. They harp on quite a bit in the decision about the fact that the nurses have specialized training distinct from the other professionals. Well, the problem with that sentence is that the very definition of a professional employee under the NLRA is someone having specialized training. Everybody who's a professional has specialized training, so that doesn't add value to the analysis.
Well, but nobody, they didn't say that it was because they had specialized training. It was because they had different specialized training. There were differences in their specialized training that gave them different roles in the medical care process. I don't think we'd be able to say it was arbitrary because they just said they were specialized.
Well, I know, but there's a cumulative effect, and the fact that, again, the decision itself talks about specialized training, in particular for the nurses, and their unique licensing being the distinctions here. But again, I will tell you, it doesn't say different specialized training. It says specialized training. No,
but it talked about how there's further training for the people who are the.
Oh, I agree. Right. I agree.
So that's what you don't think that's what they were referring to?
Well, the thing is, again, the problem is it's not elaborated upon. That's the issue.
Is it not self-evident that the nurses' specialized training is different than the social workers' specialized training?
Yeah, I think so. But why does that make a difference? Mm-hmm. That's what PCC says you have to do. You have to say, okay, there's different specialized training. Mm-hmm. Why does that make a difference for including or excluding those folks in the bargaining unit? Mm-hmm. That's the key. And once you get that concept in your head, you understand why this analysis and the decision doesn't work. They don't apply the standards that they have set forth in PCC and Boeing. Mm-hmm. And again, if you look at the Boeing case in particular, over and over again, it says, you can't do these laundry list of distinctions and stop there.
Can you point to me in the Boeing case, which of course hadn't yet been decided at the relevant time here, but right. Pointing to it, it does this step 2 analysis on pages 5 and 6. So can you point to me sort of the best example on pages 5 to 6 of where they did the type of analysis? They didn't just say, this is different from that, but that difference matters because. Would you be able to point to me just so I have a better sense? I think it'll make it more concrete for me if I have a better sense.
I understand. Like frankly, I have not looked at that for so long. It'd be hard for me to do that quickly.
Okay, well, maybe on rebuttal, you could point out on page 5 or 6 where they do their analysis there. This sort of the sentences that do this is different because this matters for collective bargaining because it's that type of because sentence that I took to be your emphasis here, that's
right.
What's missing in this case. And so it would be helpful to me at least.
Sure, no problem. Any other questions?
Does it matter that PCC structurals, the board's decision has been argued before our court in November? Did you know that?
I did not know that.
It's pending decision.
Okay.
Can I ask you, I have one other question if it's okay. You make an argument about a risk of residual units here. The people, the advanced practice practitioners, to use the sort of global term you used for the people that weren't included, I think they're about the same in number as the nurses here.
Right.
So why is there a risk of residual unit? Why couldn't they just do their own unit?
They could. But then you get into issues like, again, the policy about undue proliferation.
Yeah, but that's a different. That's
I understand.
Different. Right. So I'm asking you what your evidence in the record is of residual units. Some people who are left over who won't be able to form. That's what I wasn't clear about.
Well, I think, again.
Otherwise, they're just flip sides of the same point.
Residual units, there's a lot of factors that come into play regarding it doesn't work well having that end product, especially when you have other professionals. Why wouldn't you have normally?
I'm just asking your evidence, what your evidence in the record here that there was going to be a risk of residual units because that, for example, the advanced practice practitioners couldn't form their own unit because of all the commonalities that you noted and their size is sufficient.
Right. But that would be 5 employees. Normally unions don't go out and organize 5 employees. It just doesn't happen. So they're probably not going to be part of any bargaining unit. That's one factor. If they do to become a part of a separate union, then again, you've got the proliferation argument where you're having all these bargaining units that may result in disputes and one union honoring picket lines of other unions. And then, you just got all this patient interruption coming into play.
Got it.
And again, the proliferation issue in the decision, the regional director refers to the rule, the healthcare rule for acute care facilities that RNs are an appropriate separate unit, but that's only for acute care hospitals. It's not for non-acute. And that's what we're dealing with here as a medical center, a medical clinic.
Thank you. Let's, if my colleagues don't have any further questions for you, Mr. Potter, we'll hear from the board, and then we'll give you rebuttal time.
Sounds good.
Good morning, Your Honors. Barbara Sheehy for the National Labor Relations Board. I think I just want to start with just backing up, and we put this in our brief, but I really think it warrants highlighting that, and I'm sure the court is aware of this. Again, I'm just going to highlight it. The decision here is that the RNs were an appropriate unit. And I think sometimes lost in this discussion is, could there have been a better unit or could these people be in the unit? But I think the focus, I just want to make sure all the time, even if I misspeak, all the time that the focus is on that the board made a determination that's uniquely within its province, right? This is a uniquely board determination that the nurses in this non-acute care facility were an appropriate unit. So I wanted to start there. As I said, I'm sure the court is well aware of that and we put that in our brief, but I do think that the entire case has to be viewed through that prism, I think. And beyond what we put in our brief, unless the court has other questions, I feel like I would just be reiterating what we put in our brief. We obviously a checklist. The board walked through the distinct interests. I think it's also being forgotten a little bit in the briefing that the board is not writing on a clean slate. This regional director was not starting from scratch. There we go back 35 years for the healthcare rule, 2 years worth of data codified in that. And then beyond that, there's the 30 years after that of precedent. So beyond, like I said, repeating what's in our brief, unless the court has specific questions for me.
What's your response to their argument about Boeing?
About that Boeing, I think we responded in our brief that our response in Boeing is that, and I think Your Honor's right. I just tried to pull up Boeing, but I'm having internet issues at my house, so I'm going to have to go just on memory. But it's not my recollection in Boeing that the board goes through and lists all the factors and says this is important because this is important because this difference is important because, rather than do that, because I don't. Again, it's my recollection, so if I'm wrong, I'll stand corrected on Boeing. But I don't think that the board in Boeing did anything different than what the board did here, except in an analytical sense. Certainly in a written sense, they did, right? The board here leaned heavily into precedent and relying on cases that frankly set forth what all these differences are, that these interests are distinct, and that satisfies then the second prong of the community interest standard, that they are sufficiently distinct from the other people trying to be included in the unit, the excluded employees. So I think really the only difference here between Boeing in the analytical sense, between Boeing and what the board did here is they, again, not writing on a clean slate, they just leaned into precedent and cited the most on point 5 cases. And frankly, I'm unaware of any case that is more, I'm not aware of any case beyond the 5 that the board sites that are more on point. Certainly the employer, when it filed its request for review, when it filed its post-hearing brief, they cited cases. They're predominantly the same cases that are cited to the court, and they are frankly not applicable. So the board, I think, did exactly the same as it did in Boeing. I think it did the same in both cases, to answer Your Honor's question.
Thank you.
Can I ask you from the board's perspective, what is the relevance of the pendency of the PCC case that Judge Randolph raised? And in particular, is the underlying framework in PCC, this from your perspective, at issue in that case, or is just the application of the framework to the facts of that case?
Ooh, I'm not familiar with what specifically went up on appeal. So I'm familiar with the cases pending. I know that there's been argument, but I didn't read the briefs in the case, and it wasn't my case. So I'm going to hedge a little on the answer to say if the framework is at issue, if the court is being asked to review whether the board properly reverted to its pre-specialty healthcare standard. So if the standard is in play and the court for some reason does something in PCC structurals that calls into question the board reverting to a pre-specialty healthcare standard, then I think since the board here applied PCC structurals and its mandate to go pre-specialty healthcare, I think that we would have to ask for a remand at that point because there's a new framework. If that's not what the issue in PCC structurals, if the standard is not, like I said, I'm not familiar with what exactly is in play there, but if PCC structurals does nothing, if the court does nothing in that case or doesn't have the opportunity because it wasn't briefed that way to do anything with the standard, then this case just goes forward as it's been briefed.
Okay. Let me see if my colleagues have further questions for you, Ms. Shi. Hearing none, unless you have anything further, we'll give Mr. Potter his rebuttal time.
I don't. Thank you very much.
Thank you, Ms. Shi. Mr. Potter, we'll give you 2 minutes for your rebuttal.
Thank you. Well, to go back to your original question about page 5 and 6 regarding Boeing, I think if you just look at page 5 in particular, where they start with the step 2 process, shared interest of excluded employees, in the 3rd full paragraph, they start analyzing, some of the shared interest and distinct interest. And then you go over to the next column, the next paragraph, it says, by contrast. So again, they're starting to analyze the distinctions between the two groups. It's not simply a laundry list that's being laid out.
Well, they did that in this case as well. They say the differences are relatively insignificant in the context of collective bargaining, but I don't see any because, which I thought you wanted a because sentence.
Yeah, I
They
do.
made the same conclusion in this case, that they agree, the regional director agreed that there are, some things that they had in common. I mean, it's a little hard to transpose the words because they were finding the group here and they didn't there, but they said, yeah, sure, there are some things that they have in common, but they don't outweigh the factors.
Well,
different. They don't carry much weight because they're things in common that all employees have. So I just don't see the because stuff that I thought you said they
well, I think in particular, it's just as much of anything, it's just the lack of analysis. I mean, it's very conclusionary in our case. We find that there are not significant, distinguishing.
It might have been a shorter list of factors.
Well, no, if you turn the page before,
Mhm.
and there's a whole laundry list of different factors that come into play, and most of those aren't even addressed.
Okay, this looks to me like a list of factors that are in and are out, just like that one. It's maybe a longer list.
I think if you
I don't see the analysis. I thought your objection was not that they didn't just talk long enough about the factors, but that they didn't, you said it was conclusory. They didn't say why it
Right.
mattered. And that's what I was looking for here was the why statements.
Well, again, if you look at Boeing in depth and you go through the analysis, there's a lot on page 5 in particular.
Okay, you don't have a particular sentence you can point me to that does that why analysis.
Well, I don't think so.
Great.
All right. Thank you, counsel. Thank you to both counsel. We'll
Okay.
take this case under submission.
Thank you.
Case number 20-5085, Lee Memorial Hospital et al., appellants, Billings Clinic et al. Versus Norris W. Cochran, Acting Secretary, U.S. Department of Health and Human Services. Mr. Bradley for the appellant, Mr. Schultz for the appellee.
Morning, counsel. Mr. Bradley, please proceed when you're ready.
Good morning, and may it please the court, I'm Keith Bradley, representing the hospitals in this case. The previous proceedings involved a serious jurisdictional error in which the district court asserted jurisdiction to decide the merits of claims that the board had never considered. Today, I'd like to make 3 things clear. First, that jurisdictional defect is important. It would be valuable for the court to make plain that the secretary cannot waive a jurisdictional prerequisite that Congress assigned to the board. Second, the hospitals are not engaged in gamesmanship. They had nothing to gain from waiting to see how the merits of the appeal would turn out before raising this issue. Third, the panel's prior decision is not law of the circuit or of the case that the district court had merits jurisdiction over these claims. First, with respect to jurisdiction, the board dismissed the claims and denied expedited judicial review. That's EJR. The district court then found that the legal issues satisfied the criteria for EJR and concluded that it had jurisdiction under the EJR provisions. Under ALINA, that can't work, and the government does not contend it can. Instead, the government says it waived the need for a board merits decision. We too had accepted that at oral argument before. But for that waiver to be possible, it would have to be the case that a board merits decision is not a jurisdictional necessity. If it were, the government couldn't waive it. And in fact, HHS has told every other court, so far as we can find, that a board decision is indeed a jurisdictional prerequisite. That makes sense. The waiver
Your
concept
argued that there was jurisdiction last time. Was that a reasonable argument?
To be honest, we were mistaken when we said that.
I didn't ask
before.
whether you're mistaken.
Yeah, no.
I just asked, did you make a reasonable, albeit mistaken, argument for jurisdiction, or was it an unreasonable argument advanced to this court?
So I wanted to, if I may, I would like to distinguish 2 different things that we said about jurisdiction. First, at the district court level, we had signed up for this idea of a self-EJR finding. That was reasonable at the time, but ALINA foreclosed it. Second, to this court, we put forth the waiver idea as well. And
Post-Alina, you made.
Yeah, post-Alina, yes. I don't think that it was a good argument.
I'm not, I'm going to ask you again. Let me ask you, was it mistaken, but was it unreasonable?
I am
not even arguable, what you said.
I don't think it was arguable.
Was it sanctionable to violate Rule 11?
I don't think that we had violated Rule 11, but
you had a colorable, plausible argument.
Colorable, yes.
Plausible.
I don't think that's what arguable means in the arguable basis concept, though.
I'm just asking you to describe.
Yeah.
Because we asked for briefing.
You did.
On this question. Many questions were asked during oral argument about it.
They were.
And an argument was made to us. And my assumption was that the attorney had come here in good faith and was a reasonable, but you now think mistaken argument about this unresolved jurisdictional question. But now you're telling me it wasn't even reasonable.
I don't think it rose to the level of Rule 11 by any means, to be sure.
Did it? But you're telling me it wasn't even reasonable.
No, I don't think it was reasonable on either side.
No, I'm not asking either side. I'm asking you to talk. This was your client's argument.
Absolutely. Understood.
Unreasonable. Okay.
I don't think it was reasonable. We have now had the benefit, obviously, of thinking about this at much greater length than we had in the pressures of the time, and as much as we've read about this since then, no.
What were the pressures of the time? I thought was there a lack of time to think through the argument?
Well, several things. One is, yes, there was some amount of time pressure just because it was arising. The court did issue its order, but that we were arriving at oral argument. But then, in addition, this is one of the things that comes from these consolidated cases. There were also 30-odd hospitals there for which there was no jurisdictional question that counsel was also representing with just addressing the merits of their cases.
But it wasn't a snap answer at oral argument, right? This was an issue that had been flagged ahead of time that you had time to think through.
The court did issue that order asking us to discuss it.
And Mr. Bradley, the district court in the first go round issued an order, a final judgment that applied not only to the parties that we had jurisdiction over, but also everybody in the case. And the judgment was that on the merits, correct?
Correct.
And then when the panel heard the case, the final judgment of the panel was to affirm that ruling by the district court holding against your clients on the merits. Correct?
Correct. And
so for this panel to disagree with that would be a violation of the law of the circuit, number one, and a violation of the law of the case, number two. Isn't that correct?
Respectfully, Your Honor, I don't think that it would, for two reasons. One is, although they're both rooted in what the Billings decision said, it said explicitly, we are not deciding that the district court had jurisdiction. We are leaving that question unresolved. The sentence at the end.
And the reason is, let me just follow up here, because there's an analogy here. I don't think the parties have drawn it, but and let me explain the analogy. When we have a standing case, if we have 20 parties and one of them has standing, we don't care whether the other 19 do or not. But when we render a decision involving all 20 of those parties are bound by that decision. What's the difference between what happened in the first go round in this court and that sort of a situation which happens rather commonly in this court?
We have explored what would happen, what happens after the decision. And I want to be clear also, The decision in Billings is binding precedent for what the court said about the merit. The court said various things. That is all binding precedent for everybody. But with respect to its being law of the case or preclusive or other effects like that, binding on the party-specific fashion that you just suggested, we have searched and we have not found cases applying that effect to those other 19 parties. Now, it does not often happen. The circumstances of this case are a little bit unique in that it does not often happen that once the court has issued.
Actually, they're not very unique. I mean, it's very close to the decision of our court in Bank in LaShawn many, many years ago. I mean, 2 decades ago, and in which we held that law of the case and law of the circuit, et cetera, also apply to jurisdictional determinations.
It does, but I submit that in LaShawn you wrote that it applies to decisions made by necessary implication, whereas here the panel, it cannot be necessarily implied because the panel explicitly said they were not deciding it. And I will offer to you, in addition, a case after LaShawn called Independent Petroleum Producers Association of America, in which the court proceeded to decide a jurisdictional question that had not been settled by the previous case. There had been 2 parties, in it before the court in that previous case, and the court in the subsequent decision proceeded to say yes, but that's only things that are necessarily implied. And since it was not necessarily implied in that previous decision, we have here the authority to decide the jurisdictional question that has come squarely before us. And then in Independent Petroleum Association, the court then decided that as to this second party, there had been no jurisdiction.
No, you should have applied for rehearing or rehearing in Bank if that's your position after the initial decision by the Court of Appeals, because you lost on the merits, even though the court made no determination about whether it had jurisdiction over you. And it's the same thing as in standing. If you had a problem with that, then your only recourse was to petition for certiorari or rehearing. You didn't do either one. So
Well,
you're bound by that. Yeah.
You did petition for rehearing and you didn't raise the issue.
We did. We did. If I may, I have.
Did you not have enough time? You said there was not enough time before oral argument to sort out the jurisdictional issue, but argument was December. I think your rehearing petition was the next September.
It
was 9 months. Was 9 months enough time to figure out this problem and raise it?
It was, but if I may, about.
I'm sorry, back up. I'm sorry. You said that was sufficient time to have raised.
As far as rehearing goes, yes. But if I may, about the rehearing, two thoughts there. One of which is that, again, this comes back to the fact that these were all consolidated. There were, we believed, problems with the decision on the merits as well. And for all of these hospitals that were there and had no jurisdictional defect, they also had, within the limited space confines of a rehearing petition, something that needed to be said. And moreover, a rehearing petition, obviously the court has it has full discretion whether to grant it or not, and it is unusual to grant one, whereas the rules prescribe a mechanism for what to do if there has been a jurisdictional defect, namely a motion under Rule 60b-4, which is exactly what we did.
So because of strategic choices about how to use your word limit, you didn't raise it at rehearing and waited, I think, 2 more years to file a 60B petition? That's the theory?
Well, there is no time limit, of course, on Rule 60b-4. And then the second thing that I'd like to say
No, I'm just asking, you said you didn't have enough space in your rehearing petition, so you were aware of the issue, but because, if I can just finish my sentence. So you were aware, you had your 9 months now to think about it. So you were aware of the jurisdictional problem, but you had the folks for which there was jurisdiction indisputably, and they wanted to raise merits issues. And so a strategic decision was made just to seek rehearing on those merits questions and not to raise this jurisdictional issue that you were aware of.
To be candid, Your Honor, I do not recall whether we were aware of it at the time of the rehearing petition, but you had asked whether it would have been possible to be aware. And in the 9 months, I don't want to assert to you that we could not have figured that out.
Okay.
So I don't mean to suggest that we did make a strategic decision, simply that in the circumstances, it would not be I submit that it would not make sense to require that parties go through the rehearing process rather than through the Rule 60 process that is set out in the rules. The other thing I'd like to point out about this is that it as a practical matter, it would not have made any difference to do it one way or the other. Had the parties raised it in rehearing petition or in the oral argument, what would have happened is that the cases would have gone back, they would have been remanded to the board, they would have come back up through the process, and the merits decision in Billings would have been binding precedent, whether for good effect or as it happened for ill effect. And in fact, these same parties, many of them are litigating claims involving some of these same rules in the district court below right now. That case was actually stayed.
For the same years?
For many of the same years. I'm not sure they would cover all of the same years, but many of them, yes.
Do they include any additional years?
I believe they do include some additional years, yes.
Yes, well, that's quite different then, because our decision was very much at this time, this was reasonable by the.
Yeah, but
so what I'm
they
trying to
definitely
figure
include
out.
some of the same years.
So what I'm trying to figure out here is, what's the point? Because normally what happens in these standing cases is someone's seeking APA relief, declarative relief, injunctive relief, that's going to control their case, their position. There's nothing more to be done. And so let's say you're right. And so we agree with you, it's vacated, or mandamus, whatever one you want. We send it back to the district court and it's dismissed from there, and you go back before the board and the board gives you the EJR, and then you go back to the district court. Would you agree that the district court's decision is going to be completely controlled by the Billings decision at that point?
As a matter of circuit precedent, yes, Billings is going to be binding precedent on the district court. So it's a fair question. Why do we want to do this? There are in the court below, we are litigating further matters about some of these same rules. We believe that there is more to be said about them.
Wait, further matters like different arguments?
Different arguments, and it is outside the record. But I can say that
you're clearly bound as to these years. You're clearly bound by res judicata. If you sought summary judgment in the district court the first round, you cross moved, and so you had your chance there to raise all the arguments that you wanted. I mean, there's no way you get to fight those same years again and just say, okay, now we've thought of some new arguments.
If I may respond.
Yes.
If there is no judgment against these hospitals, I submit that there would not be res judicata against them arising from Billings, and it would only be the binding precedent, which of course has a broad sweep, but would leave room for further arguments, of which we think there are some important ones.
And are you saying that any further proceedings, if every step that you need to go through were gotten through, would happen in the district court here, or without regard to your ability to bring a claim somewhere else?
Our intent is to bring them back up to the district court. We would probably, we could not, obviously, I don't want to commit for that judge that, for that court, that it would accept them into the same case as a matter of related cases, or that they would get consolidated, but that is what we would do. That was what we would seek to do.
Okay. Unless my colleagues have any further questions for you, we'll hear from the government. Mr. Schultz.
Thank you, Your Honor. Benjamin Schultz on behalf of the government. In the original litigation, the plaintiffs insisted that this court and the district court properly could exercise jurisdiction over all plaintiffs. And this court ultimately concluded that it didn't need to resolve the jurisdictional question, and it affirmed the district court's judgment in full. Because this court concluded that it could affirm the judgment in full without need to resolve the jurisdictional question that the plaintiffs are now presenting, Billings Clinic can be the beginning and end of this case, because Billings Clinic shows that the judgment could be affirmed without need to address this jurisdictional question. At a minimum, a void judgment cannot be a judgment that the Court of Appeals says can be affirmed whether or not there was jurisdiction. Even if this court doesn't want to go that route, and we think that's just a simple, easy way to do this, even if this court doesn't want to go that route, it can also apply general principles of Rule 60b-4. This court held in the Delta Foods case that even in a Rule 60b-4 motion, if a party had a fair opportunity to attack jurisdiction the first time around, and simply declines to do so, then that party cannot attack jurisdiction in a Rule 60b-4 motion, except perhaps in some very, very narrow circumstances, which are far afield from the circumstances of this case. The case is actually an easier case than Delta Foods, because not only did the plaintiffs have a fair opportunity to raise their jurisdictional objection, they affirmatively argued to this court that there was jurisdiction. I'd be happy to address the jurisdictional arguments itself if the court wants to talk about them. Again, I don't think there's any need for this court to reach that, but if the court would like to, I'm happy to do it. I'm also happy to talk about mandamus if the court has questions there, but I think it's pretty clear that the district court in this case did issue a full and complete judgment that resolved all claims, so there is nothing to mandamus. And unless the court has further questions, we'll rest on our briefs.
I think I know the answer to this, but I'll ask for your view. Are you familiar with Capron versus Van Noorden?
I'm sorry, what case?
Capron versus Van Noorden.
I'm not specifically familiar with that one,
It's
Your
not
Honor.
actually a recent case. It was decided in 1807, I think, by Chief Justice Marshall. And it's a case where it went up on appeal, and it was a diversity of citizenship case, as I recall. And so it goes up on appeal. The plaintiff lost in the district court. And when it goes up on appeal, the plaintiff said, well, although we invoked diversity jurisdiction and lost, there really was no jurisdiction. And the question was whether the losing party is permitted to raise that jurisdictional claim when that's the party that invoked jurisdiction. How would you distinguish that case?
Well, Your Honor, I'm not familiar with it, and I don't think I don't think opposing counsel has cited it. But I will say that whatever that case said in 1807, it certainly would have predated the modern civil rules. So I think at least one way to distinguish it is we currently have Rule 60b-4. That would be the vehicle that they would use to attach jurisdiction, and this court would apply Rule 60b-4 jurisprudence in a way that wouldn't have been true in 1807. And this court's established case law under Rule 60b-4 resolves this.
I would distinguish it too, because, but on a different basis, that it was on direct appeal.
I'm sorry, I didn't understand that, Your Honor, that it was a direct appeal. That certainly would also be a grounds for distinction if that was the case, yes.
Yeah. Okay.
Can you just say, you said this most straightforward route for us to resolve the case was your first ground, as opposed to getting to Delta Foods. The first ground, we do have a 60b-4 motion that the district court disposed of, and the denial of which has been appealed to us, right? So we have to apply some standard for 60b-4. And your first ground, again, is what, in response to the fact that there is a 60b-4 motion that
so to get 60b-4 relief, the first step is you have to show that the judgment is void, which means that there's some sort of fundamental infirmity. Our initial position is there's not even any infirmity, because this court has already held, and it is the law of this circuit, that the district court's judgment could be affirmed without regard to whether or not there was jurisdiction over the motion plaintiff's claims.
Okay.
What is the government's view on what a fundamental jurisdictional error is, or when the Supreme Court said in the United Student Aid case, only quote, certain types of jurisdictional errors are covered by 60b-4?
The Supreme Court case law talks about kind of three different categories of things. One is, and there's different terminology, but I think it's more or less the same thing. One is, it talks about like a manifest lack of jurisdiction, which may be the same as there wasn't even an arguable basis for jurisdiction. Then there's two other really narrow exceptions about when there may be another tribunal and you're substantially infringing on it. And then there's, I think, a third exception, which I'm sorry. That if the original court was incapable of resolving the jurisdictional question the first time around, and we're far afield from any of those narrow exceptions. And frankly, I don't think the court even needs to get into those exceptions, because the first ground that we've presented doesn't even reach that, which is that it's already the law of this circuit that the judgment could be affirmed.
But if we look back at the time of our decision, so before we had that law of the circuit, at the time of our decision, was it arguable, or I guess manifestly erroneous, to conclude that there was jurisdiction to enter a conclusive judgment on the summary judgment, affirming summary judgment on the complaint that they joined?
So we think it was at a minimum arguable and in fact correct for at least two different reasons. One is the waiver theory, which we think is logical. It's supported by text and Supreme Court precedent. The Ninth Circuit has expressly found in a section 1395 OOF1 case that the exhaustion requirement can be waived. And we think there's case law from this and other circuits that also suggests that the term final decision in 1395 OOF1 has the same meaning that it has in section 405G. In addition, there is certainly case law that says that there are times in which it is appropriate for a court to exercise hypothetical statutory jurisdiction. And, I'm not sure that that's precisely what this court did when it decided.
No, I thought we were quite clear that we were not exercising jurisdiction over, hypothetical jurisdiction over the other hospitals. We just didn't find it necessary to resolve their jurisdiction because they were looking for declaratory relief in the case.
Sure. And I don't mean to suggest that this court engaged in the actual practice of hypothetical statutory jurisdiction, but I think what that case law shows is that there can be times in which it is appropriate for a court to resolve a case on the merits despite doubts over statutory jurisdiction, and that doesn't render the judgment void.
And with your analogy to the 405G jurisdiction, is there any case you can point me to in which the government would agree that there is jurisdiction even if no one within, under 405G, no one within the agency addressed the question, the merits question that's being appealed? No one addressed, no agency. It's not a question of the ALJ decided it, but whether they exhausted their appeal rights. No one in the agency had actually addressed the question. Would you
So I'm sorry,
agree
so you're asking, is there a situation in which, is there a case in which the government agreed to 405G jurisdiction despite the fact that no one in the agency had addressed a question on the merits?
Either the government agreed or a court has found 405G jurisdiction without any agency decision on the question that is now before the court?
My recollection is that in either Matthews v. Eldridge or Weinberger v. Salfie or both, the issue was a constitutional question that the agency disclaimed any ability to rule on. So I think
the
that
agency had first made that decision. I mean,
you
the
mean it
agency
had
first
decided
looked at
that.
the merits and said, we're passing this on.
So yes, I think you're right that they said, hey, there's this claim, but they also said we're not going to decide it on the merits.
Mm-hmm. Okay. All right. Which we didn't have here. The agency didn't do that step here. The board being the agency.
Well, I think the board said that it was going to dismiss the case entirely. You had a case that the plaintiffs said, hey, we have a case, and the board said, no, you don't. Your case is dismissed, gone, totally over.
Different grounds. Well, completely different grounds. And
sure.
On the question of presenting the merits claim, the board here never was given the opportunity to look at it and say, we think we can decide it, or no, that's outside our wheelhouse. We're sending it up to the court.
Well, I think there was a request for expedited judicial review and the board denied it. Now, maybe it denied it on a different basis rather than, whether or not it had the authority to rule on it, but it did deny the request for expedited judicial review.
Mm-hmm. Okay.
I have one last question just on your threshold law of the circuit ground, and it's just that does that apply anytime a court actually addresses jurisdiction, so that it means the 60B4 is just unavailable if the 60B4 objection is jurisdictionally grounded, anytime in the previous round jurisdiction was in fact addressed?
Well, Your Honor, I think because it's a law of the circuit question, it's about what the Court of Appeals held.
Yeah,
so,
that court, right.
Right. So if a Court of Appeals issues a binding decision, then that decision is binding until overruled by the circuit en banc or the Supreme Court.
And 60B4 is just unavailable.
Correct. So, for example, if this court had held affirmatively that there was jurisdiction over all plaintiffs, and then the plaintiffs had come in on 60B4 and said that was plainly erroneous, it would still be the law of the circuit unless and until the court en banc or the Supreme Court overruled it.
Yep. Okay. If my colleagues don't have any further questions for you, we'll hear from Mr. Bradley for his rebuttal. Mr. Bradley, we'll give you 2 minutes for your rebuttal.
Thank you. One thing I would just like to correct about what I said earlier, in the case that's going on below, these hospitals are litigating some different years and other hospitals are litigating the same years. Again, part of the complexities.
Your clients are litigating different years.
Yes. Other hospitals in those cases.
But you don't represent those other hospitals.
No, we represent all of them.
But your argument here is for the folks who are only
Correct.
arguing
Right.
about New Year's. Sorry.
Correct.
New
I just wanted to be
years.
clear about precise about what I had said. It remains true that if we were to get a remand back to the board and we come back up, we would try to add these claims into that same case where other hospitals that we represent are litigating some of these same years from billings. With respect to the law of the case, I'd like to quote a little something from the 10th Circuit case that we quoted in our brief. It cannot be the case that a court is, a theoretical consideration of a jurisdictional issue should not be confused with the implicit but actual determination necessary to invoke the law of the case. If this distinction were denied, no jurisdictional deficiency could ever escape the preclusive reach of the doctrine that would clearly undermine the efficacy of Rule 60b-4 and contradict the many decisions that have implemented the rule to overturn jurisdictionally void final judgments. That was a case in which the parties had not properly raised the issue, had taken an appeal, and then the 10th Circuit held that Rule 60b-4 relief was appropriate. We've cited other examples of that as well in our briefs. This court, as the panel has recognized, explicitly did not decide that there was jurisdiction, and I submit that that question remains open for you to decide.
In that 10th Circuit case, did they argue jurisdiction on appeal?
On appeal, they did not, had not, on the original appeal, they had not.
Right,
And then
yes, the original appeal, they had not raised it.
They had not, correct.
Okay, thank you, counsel. Thank you to both counsel. We'll take this case under submission.
This honorable court is now adjourned until Friday, February 26th at 9:30 a.m.